Today, we're diving into a concept that kind of reshapes our whole understanding of what it means to own land in Canada. It's called Aboriginal title. And it's not about deeds or property lines. It's a really unique and powerful right that's rooted deep in history itself. We're going to break down what it is, how it's proven, and why it is so critical today. Let's get right into it.
So, to really get a handle on Aboriginal title, you've got to start with a more basic question. What does it even mean to own land? For most of us, right, it means a piece of paper, maybe a fence, the right to sell it. But what if ownership wasn't about a document, but about a relationship with the land that goes back thousands of years?
And this is where you really see the difference, side by side. On one hand, you have the kind of property ownership we're all used to. It belongs to an individual, you can buy it and sell it, and it's granted by the government. But on the other hand, you have Aboriginal title. It's not owned by one person, it's held by an entire nation collectively. It can't just be sold to anyone. And maybe the most important part, it wasn't given by the Crown. It was here long before, and Canadian law today simply acknowledges that it exists.
So, how are we going to unpack all this? Well, here's the game plan. We'll start with what makes this title so different. Then, we'll look at the government's legal responsibilities. After that, we'll get into how title is actually proven in court, what it lets a nation do, and finally, we'll explore why it's a protected but not an absolute right.
All right, first up, a different kind of title. The key thing to remember here is that these are rights that predate the arrival of the Crown. This is really the foundational idea we have to get our heads around.
So here's the absolute key takeaway. Canadian courts don't see Aboriginal title as some kind of gift from the government. They see it as a pre-existing right. It's basically the law finally catching up to history, recognizing a legal reality that was already there for millennia. It's like a bridge between two very, very different legal worlds. Okay, moving on to our second big topic, the Crown's core duties. These aren't just suggestions. These are principles that are legally required to guide the entire relationship between the government and Indigenous peoples. First up is this idea of the honor of the Crown. Now, this isn't just some fancy, poetic phrase. It's a hard and fast constitutional duty. It means the government can't act unfairly or dishonorably. If they make a promise, say in a treaty, they absolutely have to keep it. It's a real legal check on the government's power. And then you've got the fiduciary duty, which honestly is even stronger. The best way to think about it is that the Crown has to act like a trustee. It's legally required to manage Indigenous lands and rights for the best interests of Indigenous peoples themselves, not for its own benefit. It's a protective duty that recognizes a historic power imbalance. And look, this isn't just a matter of opinion or some lofty idea. This is constitutional law. As you can see right from this legal text, the courts call it a constitutional principle. And that means it's a fundamental, foundational rule that shapes how every single law and government action related to Indigenous rights has to be interpreted. It's a really big deal. Okay, so that brings us to a huge question. If a First Nation believes it holds Aboriginal title, how on earth do they prove it in a Canadian court? Well, it's not easy. The Supreme Court has laid out a specific three-part test you have to pass. So, the court uses this three-part test. First, a nation has to show it occupied the land back when the Crown first asserted sovereignty over the area. Second, it has to prove continuity. A clear, unbroken link between that historic group and the community that exists today. And finally, it has to show exclusivity, proving that, historically, they had the ability to control access to that territory. But that first step, sufficient occupation, is really interesting because it's super nuanced. The courts have been very clear that this isn't about proving ownership with fences and deeds in the European sense. It's all about looking at the group's own culture, their own customs and laws. So occupation could mean a village, sure, but for a nomadic group, it could also mean seasonal hunting grounds. The whole process has to take a culturally sensitive approach to even be valid. Okay, so let's imagine a nation has gone through that whole process and has proven title in court. We're on to Section 4. What does this title actually mean? What does that right let them do? All right, we're going to hit you with a bit of Latin here, but it's super important. Sui generis. It's a phrase that means of its own kind or unique. Courts use this term because Aboriginal title just doesn't fit into the neat little boxes of Canadian property law. It's not a lease, it's not private ownership like your house. It is its own special thing with its own special rules. And you can see that idea right here, straight from the legal analysis. This text explains that because the title is sui generis, it has its own distinct features.
You can't just try to cram it into the existing legal system. It forces the system to bend, to think differently, and to respect where this title actually comes from.
So what does this unique title look like on the ground? Well, first off, it's collective. No single person can own it or sell their piece. The entire nation holds it together for future generations. It's also inalienable, which means it can only ever be surrendered to the crown. That was actually designed to protect communities from losing their land through shady deals. And finally, it's a beneficial right. The nation gets to decide how the land is used and can benefit from its resources.
And that brings us to our last section, which is really where the rubber hits the road in the modern world. This right is powerful, and it's protected by the Constitution, but it's not absolute. So what happens when it conflicts with, say, government plans for a new pipeline or a mine?
You can kind of see how this all unfolded over a few key dates. 1982 was huge. That's when Section 35 was added to the Constitution, officially recognizing Aboriginal rights. Then you have court cases like Sparrow that started to define what that actually meant. But the real game changer was in 2014 with the Teal-Cottonleation decision, which was the first time ever that the Supreme Court of Canada formally declared Aboriginal title over a specific piece of land.
And this gets to the heart of so many modern conflicts. Even though the right is protected by the Constitution, it's not an absolute veto. A government can infringe on it to build something like a highway or a dam, but, and this is a huge but, the burden is entirely on them to prove that infringement is absolutely necessary and justified. And this is the test for that justification. It's tough. First, the Crown has a duty to consult meaningfully with the title holders and accommodate their concerns. Second, the government needs a compelling public objective, not just something minor. And third, the action must be proportional. It has to align with that fiduciary duty we talked about and infringe on the title as little as humanly possible. It is a very, very high bar to clear.
And that leaves us with this final, really big thought. The law has built this complex framework, trying to balance crown sovereignty with pre-existing Indigenous rights, all in the name of reconciliation. But the bigger question, the one that goes beyond the courts, is this: how do we as a society navigate these fundamentally different ways of seeing the world? One view sees land as a collective inheritance, a relationship. The other often sees it as a commodity to be bought and sold. The legal answers are slowly taking shape, but the social and cultural questions, well, those are the ones we all continue to grapple with.